So I have an important update in the suppressor freedom lawsuit, which aims to remove a state ban on the purchase and possession of suppressors. So let's talk about what is happening. Now, really quick before we jump into this video, if you guys want to support the channel for free, please consider subscribing. Also hit the notification bell and turn on all notifications because that helps to ensure that YouTube will actually send you these videos. Also, just drop a positive comment down below because that helps to tell the algorithm that you appreciate this type of 2A content and it should share it to more people. As I mentioned in the intro, in this video, I have some important updates in a lawsuit which aims to remove a statewide ban on the purchase and possession of suppressors. The case we're going to be talking about in this video is Morse versus Raul. This lawsuit was filed in a federal district court in the state of Illinois, and essentially it aims to remove the state's ban on the purchase and possession of suppressors. This lawsuit could kind of be the first one in the nation which finds that a state's outright ban on NFA items like suppressors is in fact unconstitutional and violates the Second Amendment. This would also be very important and could impact other state bans on the possession of SBRs and other items, again, like suppressors, where states like California and others have restrictions on your access to those type of items. Now, currently in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore they are not protected by the Second Amendment at all. The state of Illinois is currently requesting that the judge in this case grant a judgment on the pleadings in the state's favor and throw the case out right here and now. The judge in this case has now set a hearing to review this challenge, and it's going to happen at the end of this month, and he will decide whether or not suppressors are protected arms and whether or not this case should proceed forward towards the final merits. Now, in this case, the plaintiffs argued that suppressors are not dangerous and unusual items, and the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. Instead, these are common arms owned by law-abiding people for lawful purposes like self-defense and other purposes. The entire motion is based on the state's argument that this case should be thrown out because there is no valid 2A claim. And they say there is no valid Second Amendment claim because they say suppressors are not arms. In their motion, Illinois argues that the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary to the effective use of a firearm. They are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. They go on to argue that while an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit within the founding era definition of an arm. But a silencer is not itself used to cast at or strike at another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. And while some people find silencers useful, they are not so critical to a firearm ownership that firearms cannot be used effectively without them. Silencers are therefore not arms within the original meaning of the constitutional text. The state of Illinois goes on to argue that silencers do not satisfy this definition of arms. A silencer is a firearm accessory. It's not a weapon itself, nor is it an armor of defense. So the state's primary argument is that suppressors cannot be considered an arm because they're not a weapon, they don't shoot a projectile. Instead, they're saying that they're simply an accessory, but not a necessary accessory. Now, of course, that contradicts the fact that the federal law and the NFA actually treat suppressors as firearms, but the state here wants to ignore that fact, and they want the court here to dismiss the case early and follow a string of other decisions in other circuit courts that found similar ways that these type of items are not protected arms. Now, the hearing on the motion was temporarily stayed while the judge, was considering some other cases, and he was waiting for the Illinois rifle ban decision, which he believed would likely impact the outcome of this suppressor case. Now, the judge in the suppressor case wanted to see how the other lower court applied the Seventh Circuit's recent decisions when it came to rifle bans and magazine bans. Also, with the Protection of Illinois Communities Act, the PICA case, there are restrictions within that law on various characteristics and accessories like flash suppressors and threaded barrels. And so the judge here in the suppressor case wanted to see how that would play out. Well, recently Judge McGlynn did issue a lower court decision striking down the PICA case as unconstitutional. And because of that, the plaintiffs in the suppressor case have submitted that win as support for why the motion for judgment on the pleadings should be denied and also why the suppressor ban should be struck down. Now, in response to that, the state of Illinois has submitted their own supplemental notice of another case that came out of the Fifth Circuit, and it's a case we've covered in the past called U.S. versus Peterson. The Peterson case involves an individual who had a gun store that was raided by the ATF. During that raid, the ATF found a single solvent trap that was not registered or serialized under the NFA. And because of that one item, Mr. Peterson was charged with violating the NFA. Mr. Peterson and his attorney tried to get the case thrown out and get those charges thrown out by arguing that they violated the Second Amendment, but ultimately the district court denied that motion, finding that silencers are not bearable arms and not protected by the Second Amendment. That decision was reviewed by the Fifth Circuit in a 3-judge panel, and ultimately the 3-judge panel of the Fifth Circuit agreed with the federal government, and they found that suppressors are not arms and they are not protected under the Second Amendment, and they kind of followed the line of rationale that these are not actual arms, that they're simply accessories, that they're not necessary accoutrements, they're not required for the function of a firearm, and therefore because of that they're not protected. Now in this notice, Illinois argues that Peterson holds that suppressors do not trigger Second Amendment protection, thus rejecting the same theory pressed by plaintiffs in these consolidated actions. As the Fifth Circuit explains, whether suppressors constitute arms is an issue of first impression in our circuit. Insofar as we can tell, every court that has addressed it has decided the question in the negative. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. And while possession of firearms themselves is covered by the plain text of the Second Amendment, possession of a firearm accessory is not. As the government aptly explains, an operable firearm will work perfectly well without a suppressor, but a suppressor will not transform an inoperable firearm into an operable one. Moreover, it can hardly be said that suppressor regulations have rendered the right to bear arms meaningless. The use of a suppressor, as we noted above, is not necessary to the use of a firearm, so it is not protected by the plain text of the Second Amendment. That decision by the Fifth Circuit is likely going to be reheard by the Fifth Circuit en banc panel. Right now, there's a petition for a rehearing, but the state of Illinois is trying to use this case, and they're trying to use it to justify why their suppressor restriction should be upheld and why this case should be thrown out early. Now, there's also a caveat where the Fifth Circuit Peterson case, has some input right now by the AG's office, by Pam Bondi in her office, and they've notified the Fifth Circuit that they are reevaluating the administration's approach when it comes to suppressors. So even in that challenge in the Fifth Circuit, a lot could change. Well, now this Illinois suppressor challenge is coming to a head. The judge has now set the hearing for the motion on the judgment on the pleadings to take place at the end of this month on April 30th. Judge David Duggan is the one responsible for this case, and he will now decide whether he will follow suit like the Fifth Circuit and like that Fifth Circuit 3-judge panel and other circuit courts like the 10th Circuit, or is he going to find that suppressors are protected arms, that they're not merely accessories, that they're not these types of items that are non-necessary items. And so he's going to have a lot of power to determine if this case is going to proceed forward towards the merits of the challenge, or is he going to throw it out early like the state of Illinois wants. So this is something that we're going to be watching closely because this is kind of going to be the initial ball game here. If the plaintiffs here cannot get past this initial hurdle, the case will be thrown out and then they could appeal this to the 7th Circuit. But we know that the 7th Circuit has been horrible when it comes to 2A issues. So you kind of want to win this first battle, move this case towards the final merits, so that eventually when you do have to appeal to the 7th Circuit, even if they issue a horrible decision, it gives you more authority and more power to potentially elevate it to higher levels like the Supreme Court, because they want these, comprehensive final merits challenges. It would also be nice if you had this lower court here find that suppressors are arms, that they are protected, because it would start a circuit split in some ways and potentially put more pressure on the 7th Circuit to have to rule the same way. Now the 7th Circuit is going to kind of do their own thing, but at least it would start it on the right track to find that suppressors are protected arms. So as we get more information, as this develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.